Hello everyone, myself Prasiddhi Joshi. I am from BLLB batch 2. My specialization is in criminal law. Today I will be talking about rule of law which was emerged in England especially by A.V. Dicey, and it simply means that no government is above rule of law and everyone is equal before law. Application of the doctrine of rule of law. In England, the doctrine of rule of law was applied in concrete cases. For example, if a man is wrongfully arrested by police, he can file a suit for damages against them as if they were private individual. In Wilkes versus Wood, 1763, it was held that an action for damages for trespass was maintainable even if the action complained of was taken in pursuance of the order of a minister. In this case, police officers searched the house of the petitioner without any legal warrant or without any reason. Then, in Antrick versus Carrington, 1765, a publisher's house was ransacked by the king's messengers sent by the Secretary of State. In an action for trespass, £300 were awarded to the publisher as damages. Now we will see the merits of the doctrine of rule of law. The doctrine of rule of law provided to be a powerful weapon in keeping administrative authorities within their limits. It also served as a touchstone to test all administrative actions. The broad principle of rule of law was accepted by almost all legal systems as a constitutional safeguard. The first principle is supremacy of law. It the first principle recognizes a cardinal rule of democracy that every government must be subject to law and not law subject to the government. Basically means everyone is equal before law and law will not work according to government, but government have to work legally according to law. It opposed arbitrary and unfettered discretion to government authorities, which may interfere with the rights of citizens. The second principle of rule of law is equality before law. It is important to determine, it is important to a democratic government. It is based on the maxim, however high you may be, law is above you and all are equal before law. Means even if the king makes a mistake, he will be punishable just similar to a common man or a citizen. The third principle is individual liberties. It places emphasis on the role of the judiciary in enforcing individual rights and personal freedoms irrespective of their inclusion in the constitution. Mere, mere inclusion of fundamental rights in a statute would be meaningless if they cannot be enforced. Now, we will see the demerits of the doctrine of rule of law. The first principle is the supremacy of law. It was criticized on the ground that Dicey equated supremacy of rule of law with absence of not only arbitrary powers but even of discretionary powers. According to him, whenever there is discretion, there is arbitrariness and failure to distinguish between arbitrary powers and discretionary powers. Also, no welfare state can function effectively without exercise of discretionary powers. It cannot be said that once law ends, tyranny begins. Necessarily, there are many cases. As per Casey Davis, where the law ends, discretion begins. No modern welfare state can run by a government of law alone and not of man, in the sense of eliminating all discretionary powers. The second principle propounded by Dicey was fallacious in so far as the understanding of the real nature of droit administrative. He was under the impression that the administrative codes of France, including the Council d'Etat, conferred on government officials special rights, privileges, and prerogatives as against private citizens. But in reality, the French system proved to be more effective in controlling abuse of administrative powers than the common law system. Council d'Etat was technically a part of administration, but in substance, it was very much a court as it comprises of real judges. During Dicey's time, the crown enjoyed immunity under the maxim, the king can do no wrong, and thus equality before law was not followed in strict sense in England. Then came the modern concept of rule of law. In today's date, Dicey's rule of law cannot be accepted totally. Casey Davis said, fourth seven principle meaning of the term rule of law. First was law and order, then came fixed rules. Third one was elimination of discretion. Fourth was due process of law or fairness. Fifth, natural law or observance of the principle of natural justice. Sixth is preference for judges and ordinary courts of law to executive authorities and administrative tribunals. And then last came judicial review of administrative actions. Now we will talk about rule of law under the Constitution of India. The preamble enunciates the ideals of justice, liberty, and equality. Part 3 comprises of the recognition as well as enforcement of the fundamental rights. The Constitution is supreme, and the three organs of the government, which are the legislature, executive, and subordinate to it, all three organs ought to function in consonance with the Constitution. Doctrine of Judicial Review, Article 32 and 226, which talks about writ petition. If any executive or legislative action contradicts any of the constitutional provisions, the same can be quashed by the courts. Also, all the rules, regulations, ordinances by law, notifications, customs, and usage are laws within the meaning of Article 13 of the Constitution of India. If ultra virus can be quashed by the judiciary, the President is required to take an oath to preserve, protect, and defend Constitution. No person shall be deprived of his life or personal liberty except according to the procedure established by law under Article 21, or of his property saved by authority of law under Article 300A. There is equality before the law and equal protection of law under Article 14. Government and public authorities are subject to the jurisdiction of ordinary courts of law, and for similar wrongs are to be tried and punished similarly. They are not immune from ordinary legal process, nor is any provision made regarding separate administrative courts and tribunals. Exception is scat. Suits for breach of contracts and torts committed by public authorities can be filed in ordinary law courts, and damages can be recovered from state government or union government for the act of their employees. Now we will see a very important case law, which is Additional District Magistrate Jabalpur versus Shivkant Shukla 2017. It's also called as habeas corpus case, in which a petition was filed for lakhs of people. First, we will see the background of case. Before ADM Jabalpur case, a case was filed, which is state of Uttar Pradesh versus Raj Narayan. In this case, Raj Narayan has contested the 1971 Indian general election against Indira Gandhi, who represented the constituency of Raebareli in the Lok Sabha, the lower house of the parliament. Gandhi was re-elected from Raebareli by the popular votes, and her Indian National Congress party won a sweeping majority in the Indian parliament. Narayan filed a petition to appeal the verdict, alleging that Indira Gandhi used bribery, government machinery, and resources to gain an unfair advantage in contesting the election. Narayan specifically charged Gandhi of using government employees as election agents and of organizing campaign activities in the constituency while still on the payroll of the government. In this judgment, on was held that on 12 June 1975, Justice Jamohan Lal Singh found Gandhi guilty of electoral malpractices. Sinha declared the election verdict in the Raebareli constituency null and void and barred Gandhi from holding election office for 6 years. The court order gave the Congress 20 days to make arrangements to replace Gandhi in her official post. Indira Gandhi filed for an appeal in Supreme Court. Now we will see the facts of ADM Jabalpur case. On 25th June 1975, Jayaprakash Narayan organized a large rally in Delhi where he appealed police officers to reject the orders of government if the order was immoral or unethical. Such a statement was taken as a sign of inciting rebellion in the country. Later in the day, emergency was declared in India by President of India, Fakhruddin Ali Ahmad, under Article 352 on the grounds of internal disturbance. An order was also issued by the Parliament under Article 359 Clause 1 that fundamental rights, including the rights under Article 14, 21, and 22, would not be enforceable, which that no one would be able to approach Supreme Court or High Court to enforce their fundamental rights. Article 359 suspension of the enforcement of the rights conferred by Part 3 during emergencies. Clause 1 states that whether a proclamation of emergency is in operation, the President may, by order, declare that the right to move any court for the enforcement of such of the rights conferred by Part 3 shall remain suspended for the period during which the proclamation is in effect. This means that no petition for the issuance of the writ of habeas corpus would be maintainable for any case of detention. At that time, the primary that was used to detain people was the Maintenance of Internal Security Act 1971. It gave all encompassing power to the government to detain people even without conducting a trial under the act. People detained under this act approached various high courts across the country challenging the provisions of Article 359 and claiming that their rights under Article 21 and 22 were being infringed. Petitions for the enforcement of the writ of habeas corpus were filed under Article 226, and it was held by many courts that the writ of habeas corpus was maintainable even during emergency. The government raised a preliminary objections to maintainability of the petitions on the ground that in asking for the release by writ of habeas corpus, the petitioners were in substance claiming that they had been deprived of their personal liberty in violation of the procedure established by law. But such a plea was available to them only under Article 21 of the Constitution, and since enforcement of Article 21 of the Constitution was suspended by the Presidential Order of 27th June 1975, the petitions were liable to be dismissed at threshold. The matter went before the Supreme Court in instant cases where the government challenged the relief given to various detainees by the High Courts. The case was heard by a five-judge constitution bench consisting of Chief Justice A.N. Ray, Justice M.H. Beg, Justice P.N. Bhagwati, Justice V. Chandrachud, and Justice H.R. Khanna. The central issue before Supreme Court was whether there was any rule of law in India apart from any irrespective of Article 21 of the Constitution of India. The judgment was given by a majority of 4:1. Additional District Magistrate Jabalpur case was given in 4:1 case. The majority judgment said that the constitution is the mandate, the constitution is the rule of law. No one can rise above the rule of law in constitution. The rule of law is not a merry catchword or incantation. Rule of law is not a law of nature consistent and invariable at all times, and in circumstances the certainty of law is one of the elements in the concept of the rule of law, but it is only one element and taken by itself affords little guidance. The suspension of right to enforce fundamental rights has the effect that the emergency provisions in part 18 are by themselves the rule of law during time of emergency. There cannot be any rule of law other than constitutional rule of law. There cannot be any pre-constitution or post-constitution rule of law which can run counter to the rule of law embodied in the constitution, nor can there be any invocation to any rule of law to nullify the constitutional provisions during the times of emergency. The dissenting judgment was given by Justice Khanna. He said rule of law is the antithesis of arbitrariness. Rule of law is now the accepted norm of all civilized societies, even if there have been deviation from the rule of law. Such deviations have been court and disguised, for no government in civilized country is prepared to accept the ignominy of governing without the rule of law. The rule of law has come to be regarded as the mark of free society. Its content is different in different countries. It is, however, identified with the liberty of the individual. It seeks to maintain a balance between the opposing notions of individual liberty and public order. The principle that no one shall be deprived of his life and liberty without the authority of law was not the gift of the Constitution. It was a necessary corollary of the concept relating to the sanctity of the life and liberty. It existed and was in force before the coming into force of the Constitution. Even if the absence of Article 21 in the Constitution, The state has got no power to deprive a person of his life or liberty without the authority of law. This is the essential postulate and basic assumption of the rule of law, and not of man in all civilized nations. Without such sanctity of life and liberty, the distinction between a lawless society and one governed by laws would cease to have any meaning. The principle that no one shall be deprived of his life or liberty without authority of law is rooted in the consideration that life and liberty are priceless possessions which cannot be made a plaything of individual whim and caprice, and that any act which has the effect of tampering with life and liberty must receive sustenance from the sanction of the law of the land. Article 21 incorporates an essential aspect of that principle that makes it part of fundamental rights guaranteed in part 3 of the constitution. It does not, however, follow from the above that if article 21 has not been drafted and inserted in part 3, in that event it would have been permissible for the state to deprive a person of his life or liberty without the authority of law. At last, the Indian judiciary was criticized worldwide for the judgment where right to life was not given importance. But after 2 years in the case of Maneka Gandhi versus Union of India, court realized its mistake and held that right to life and liberty is mandatory, and it's a right basic fundamental right which cannot be snatched even during emergency or any other time. Thank you.